Good evening, everyone, and welcome. My name is Paul O'Neill, and on behalf of Kingston's Buried Treasures, I'd like to welcome everyone to this month's presentation in our series. And tonight, we're going to talk about the single most important event in Kingston's history, the New York State Constitutional Convention, which took place from March 6th to April 20th, 1777, right here in the Ulster County Courthouse. And the events that occurred here during that short period of time literally changed the world. And the men who met here represented the best that our nation had to offer at a time when our nation had the best that could be offered. And we're very, very honored tonight to have as our featured presenter the Honorable Albert Rosenblatt. Judge Rosenblatt is a graduate of Harvard Law School. He served 2 terms as district attorney in Dutchess County. He's a former Dutchess County Court judge, New York State Supreme Court judge, New York State Appellate Division Justice, and from 1998 to 2006, he served as an associate judge at the New York State Court of Appeals, which is the highest court in New York. He currently serves as of counsel for McCabe and Mack LLP in Poughkeepsie, and he teaches as a judicial fellow at the NYU School of Law. So we talk about people who have reached the pinnacle of success in their respective fields. Judge Rosenblatt is the real deal. In fact, we've had one and only one subject in our series who has achieved the success that Judge Rosenblatt has in the legal field, and that would be Alton Parker. And you may recall that Alton Parker was also a Court of Appeals judge and a 1904 candidate for the Democratic Party for President of the United States. But Judge Rosenblatt also represents all that we have hoped to achieve with this series, and that is to honor our local history and the significance it's had here and beyond. And by honoring our history, Judge Rosenblatt honors us. So it is a great privilege, and I'm very proud to be able to introduce tonight's featured presenter, Judge Albert Rosenblatt.
Thank you. Thank you. Thanks, Paul. Well, and how lucky you folks are to have Paul O'Neill, who's the commissioner and is able to, with his wide reach, get a group together. Do these both work kind of even, or do I favor one more than the other? This is the one. This is the one I speak through, and this is the one that comes back into my ear, right? It goes around in a circle.
Yeah, you just stay in the middle. This is for the
for you back there. Okay, so
I actually summon. I have the ability to summon people, and then we've always had a full house as a result.
All right, you know, when the commissioner juror speaks, everyone listens. And it's so good for me to be here. I mean, why am I here? I live across the river, I'm a neighbor, but I welcome the opportunity to get together for a nice Friday evening with a group of like-minded people, because we all share the legacy that we do in the Hudson Valley. We were born in Kingston, and when I say we, I mean the corporate we, in the sense that we may have come from different ethnicities and different backgrounds, and maybe we came from Scotland, Ireland, Germany, Austria, Spain, wherever, but we do share a legacy and a heritage of being New Yorkers. And that heritage began. You know, when you're speaking about heretics, we did become somewhat heretical in 1776, but we have more or less made the peace with George III, and we're fine. That heritage goes back to our date of birth, you might say, which was the creation of the Constitution in 1777. And what a lot of people do not know or do not realize, if you were to poll, I would guess even 100 college graduates in this region or in any region, and ask which came first, the United States Constitution or the constitutions of some of the several states, most people would say, well, of course the US Constitution was the founding document. The United States Constitution was the founding document of the nation in Philadelphia, drawn in 1787 and ratified in 1788, but it was 10 years before that that we were born and that we created the Constitution. There's seats up here if you like. We created the Constitution of New York. That was our governing blueprint, our document, much the same as the other colonies, fledgling states, created their state constitutions. What is a constitution? And it's apt to ask that question. It is in one sense, it's a roadmap for government. And in any constitution, if you look through the United States Constitution, and it'd be interesting to look around or go online and just punch in U.S. Constitution, and you'll find Articles 1, 2, and 3, Article 1 being the legislative, Article 2 being the executive, Article 3 being the judicial branch. And you'll understand how these three branches work together, what their duties and responsibilities are. It's possible to govern a state or a nation without a constitution by a series of statutes and enactments and common law. England, our parent, has no written constitution. They do not have anything like the document that we created in 1787 nationally or in 1777 here in Kingston. And yet they flourish, they do well, and we took our common law from England. So it's apt to ask what a constitution is, and we'll get into that a little bit later as we expand on how and what the Constitution is and how it came to be. But it's so good to be among you folks here because unlike in a class where students are obliged to attend, you're here because you want to be here, and I'm here because I want to be here. The only reason that Julie and I are here and took a nice ride across the river is because we like being among kindred folks who appreciate what our background is. And so we know something about really who we are. We know about our families, but the larger family, in the sense the corporate family of what we are as New Yorkers, is a tale that we love to tell. And we particularly love to tell it here in Kingston because Kingston was the location in which we, in a sense, were born. So let's go to some of the slides, and we could look at that. I'm going to put this on now. Has anyone ever had cataract surgery? Any of you? No? Okay. Well, I just had it recently, so I've got these glasses that help me read a little bit. I can see out there pretty well, but now I use these. This first document here was printed in Fishkill, because as some of you may have known, we declared our independence from England in 1776, on July 4, 1776, and over the ensuing months, we began to create the documents by which each of the colonies, which is to say each of the new states, began to govern themselves. And the document was printed, although formalized and approved here, it was printed in Fishkill, and that document and the attending drafts that go with it is at the state library. So we have these documents now, and if you're ever in Albany and want to go up there, some of these documents are still around. Indeed, in reading the book by Lincoln, who wrote 5 volumes on state constitutions, if you ever want to go deeper into this, read Lincoln. Charles Z. Lincoln, if you want to penetrate and drill down further. That goes way beyond what we're going to do here tonight. But I consulted Lincoln in order to sharpen up on some of the more arcane points. And he makes known that some of the original drafts with the interlineations and the margins are in Albany. Where did this happen? When we broke free from England in 1776, the war started. The British took over New York, and we recognized that while we're breaking away from England, we have to have a blueprint for our government. And in doing so, we began it in New York, we began writing it, and the British chased us up the Hudson from New York to White Plains, to Poughkeepsie, to Kingston, and here's where we actually wrote. When I say we, it sounds a little swell-headed that we wrote it. We know that that John Jay and Gouverneur Morrison and Robert Livingston wrote it, but I speak of the corporate we. And here's the building. To me, I mean, this is just, it's almost chilling to look at that building and to think that these 3 people of an average age of about 29, 2 of them were under 30, and John Jay was 31, actually composed a document as to how to create a government without any practice and without any model, because this was one of the first times in all of history that governance fell not to the king, not to the chieftain, not to the emperor, not to the queen, not to the sultan, but to the people. So how do you write a document giving power to the people? And that was the job that they did, and they did it in this building. Paul, can you tell us a little bit about that building? Because I couldn't find the picture of the building in which they wrote this online, but I emailed Paul, and Paul said, here it is. So here it is. Paul, can you give us a couple of words on that?
Yes, this is what we call the 1777 courthouse, but it was really constructed as a result of a ordinance passed in 1732. The original courthouse, we believe, the first courthouse was built on the same area in 1683. And it probably would have been wood. That lasted until 1732, at which point a resolution was passed to build a new courthouse and jail. We know that construction was going through 1737, but this is what that courthouse became. And the interesting thing is right here, we think, is probably where the Constitutional Convention occurred. In the basement was the jail. So during 1777, the Ulster County Courthouse became the Provincial Congress's jail. So they actually took out all the criminals and they put in all the Tories and Loyalists. So the jail was in the basement, and you can tell that there's bars on this side. Now, the current courthouse, this courthouse was the courthouse that was burned by the British on October 16, 1777. The stone portion remained. The wooden portion was burned away. The settlers, or the citizens here, immediately began rebuilding it, and the courthouse was again put into use until 1816. In 1816, this courthouse was taken down to its foundation, and the current courthouse was built, the 1818 courthouse. This is the first. It was built in the same foundation. This was the first front structure. There was an addition put on here in 1834, and several in the back between 1834 and the final addition in 1899. But again, this is the courthouse where the New York State Constitutional Convention met. And an interesting story is one of the first motions made at the New York State Constitutional Convention was made by Gouverneur Morris. And that motion was that the delegates be able to smoke during deliberations because the smell from the jail was so bad, they feared for their health. You know, we gloss over the fact that we treated the Loyalist prisoners horribly, but we did. And the smell was so bad. And the local legend was that that motion failed due to the Dutch influence and aversion to tobacco, and that they moved the Constitutional Convention down the road to the corner of Maiden Lane and Fair Street to the Bogartis Tavern. That's not true. The motion did pass. It only passed by 3 votes, but it did pass, and the delegates were able then to smoke to their heart's content. They apparently covered the smell and completed the important work in this courthouse.
Wow, thank you. What a nice, great. Let's have a hand for that. Way to go. That's terrific. Wow. Isn't it great to know that you've got a commissioner who can just step right in there and give us a history like that? It's still, I find it a little bit chilling to look at that building and to realize that these 3 young guys, when I think what I was like at 29, oh my God, and these guys are actually writing for the first time a blueprint on how to run a government when it had never been done before. Just think of the task. It was, in the other nations, it's simple. The king does whatever the king wants to do. The emperor decides it. There's monarchy. There's tyranny associated with it. And that's the end of that. In England, they grew up a parliament, but there was nothing like the notion, which was Lockean, John Locke, about the people having rights, and the notion, the extraordinary notion, for the first time in the world after 17 centuries and more than that in prehistory, that government function with the consent of the governed. That was an idea that was extraordinary in the history of the world, because for thousands of years before that, there was nothing about the consent of the governed. There would be governments, and the chieftain would be the government, or the king, or the emperor. So here we are now in 1777, and they are writing the Constitution of the state of New York. And like any historian, even an amateur historian like myself, naturally you don't begin on the date in question. You have to go back a few months as to how this Constitution was born. So when we go back from April 1777 and go back 9 months, it's almost 9 months, almost to the day, the gestation period, we come to July 4th, 1776. Isn't that extraordinary? So almost 9 months later in this gestation period, from the time of the Declaration of Independence until April of 1777, that was the gestation period for us. And as I said, during that time, we were being chased up the river by the British, and here is a picture of the Great Chain. Now that chain I got online, and you can, by the way, you can find all these images online, and they're really fun. Just go to Google and punch in the words, and you'll come across them. This was the Great Chain of 1778 that we put across the river at West Point in order to slow the advance of the British Navy. But before that, we had put across an earlier chain, not as famous as the Great Chain, but the Great Chain, which followed slightly later, has been retained and is at West Point, and there's a picture of it. The location of the chain is shown also from a picture that I got online. If you go to Google and punch in images, you can get pretty much anything. So if you want to go down to West Point and see what that Great Chain looked like, and look at how thick the iron was in the how it's forged here, you'll see what a remarkable instrument it was. So, with and without the help of the Great Chain, we were able to maintain our bearing and wrote the Constitution along the way. So, where does that leave us now? We have to go back, in order to appreciate the fullness of the Constitution of 1777, we have to go back to our earlier origins, not under the British, but to when and where we were born, not as New Yorkers, but where we were born in our antecedent life. We tend to think of ourselves as English, and we really are. Our common law is English, our language is English, and language is so important in terms of our culture. We speak English, and therefore we're in a sense English. We see the English as our English cousins. We're in a sense Western, the outgrowth of Western Europeans. Our language is English, our customs and our culture in many ways is English, and by that, of course, I include the British Isles of Ireland and Scotland as well. Excuse me, but before that, and from 1609, when the New World really began, until 1664, we were Dutch. And the Dutch left us with a fascinating legacy that remains here in Kingston and to some degree in Poughkeepsie, more so than pretty much anywhere else in the state. Albany was Fort Orange. Kingston was a Dutch fort along the way. Hudson was commissioned by the Dutch East India Company to find a trade route for trade in spices in the Far East, and tried to take a route that would get him there, but instead, looking for China, he found the river that bears his name, and he got up as far as Albany, and he realized that, like many other people who reach Albany, he was in a bad place. And then he recognized that his ship came to a stop there, and he realized this is not where I want to be. Turned around, but went back to Holland and said that, in effect, that I did not find the route to China, but we found some extraordinary things along the river up as far as Albany and then west along the Mohawk, which basically was beaver and trading with Indians. And so the Dutch, recognizing an opportunity for trade, because when we were Dutch, we really began our lives as New Yorkers, as traders. We were different from other parts of the country. Our life began in New Amsterdam with the Dutch, not as a theological community. We didn't begin here to set up a theology or a religion. And unlike in the South, we didn't go there to plant tobacco and become farmers in what turned out later to be a slave economy. We were here to trade. And that conception that we began as traders was revealed in a wonderful book by Russell Shorto called The Island at the Center of the World. Paul, I'm sure you know it well. And if you folks are not familiar with it, I imagine some of you are, but if you're not familiar with it, I suggest, I urge that if you have enough interest in this to come into this room on a nice Friday night, read Russell Shorto's book called The Island at the Center of the World, because that captures our essence as New Yorkers and how we formed our character and our personality as New Yorkers, basically as traders. And that same personality gave rise to an attitude of tolerance, an attitude of non-conquest, an attitude of accommodation with the Indians, and an attitude of freedom of conscience, which we have carried with us more or less to this day, and is one of the primary manifestations of the Constitution of 1777. So it's really inapt to talk about the Constitution of 1777 without revealing its earlier debt. So this document here, wait a minute. This one. Oh. Okay, that document is written in Dutch, and it is the Treaty of Westminster, by which, when the British took over in 1664, we became, in essence, British, and we were a British colony for a century until we revolted and became a state in 1776. The Treaty of Westminster in 1674 marked an agreement between the Netherlands and the British, giving over New Netherland to the British, and it became New York. So that's an important piece of history that we should recognize. So here I thought I would just review some of these dates with you, and we can look at them and see what they represent. Can I have that for a second, Paul? So this is a little bit of dating, and I'm doing this so that you get the big picture of what these dates are all about. We were under the Dutch rule from the 1620s until the 1660s. Kingston was founded as a fort in 1658. This is just to give you a sense of the decades. Then England took control in 1664 and enacted a treaty with the Netherlands in 1674. In 1674, we became English. We were under the cognizance of the Crown and the Duke of York, after which New York was named. And he divided New York into 12 counties, including Ulster. And that included portions of Sullivan and portions of Delaware. We in Dutchess County were a separate county, but we were ruled by the organization was in Kingston, but it extended to Dutchess. So our seat was in Ulster, even though we were separate. And we then became a separate government some years later. Then, 1777, the state constitution was promulgated in Kingston. 10 years later, the United States Constitution in Philadelphia. And then the following year, 1788, after we had written the Constitution in 1777, we then went around to the states and said, do you want to buy into this Constitution? Do you want to be part of the Union? And the word Union represents what happened in 1788, where New York, New Jersey, New Hampshire, Connecticut, South Carolina, and the other states said, yes, we want to join. So in the summer of 1788, each state held a convention at which the question was, do we in Virginia, New York, New Jersey, whatever, want to join the Union? This convention was held in New York in 1788, and New Yorkers agreed to join the Union, and that was the ratification of the United States Constitution. And we've been a nation ever since that time, 1788. Not 1787. 1787 we wrote the Constitution, but it was not ratified and bought into by the states until 1788. So that's just a little bit of dating, so you can get the big picture. So let's now turn to the document the document itself, yeah, let me give this back to you. And look at some interesting provisions that I think reflect a little bit of what we're all about as New Yorkers and how we may have been a little different than, in some degree, than the other states. And one of the extraordinary things I found in looking at this document in 1777 was that of the original 13 state constitutions, all of them, except New York and Virginia, required that only Protestants could hold office. Now, it should not be shocking because we were, at that time, less diverse than we are now. We were largely Protestant, not entirely. There were other religious groups around. But it would come as no great surprise, because we were predominantly Protestant, that the state constitution said, well, we're Protestant, we want only Protestant office holders. We did not say that in New York, and I think the reason we did not say that in New York, because our culture had grown up under the Dutch, who gave us a sense of accommodation and a sense of diversity that was lacking in most other states. This goes back to the original implantation of the Dutch on New York or New Amsterdam soil, in which one of the early documents that the Dutch brought with them when they set foot in the New World was when one of the first governors before Peter Stuyvesant set foot in New Netherland in the 1620s. The Dutch government gave him a set of instructions. And we have these instructions. They exist. You can go online, you can read them. And the instructions were, of course, how to proceed in the New World, because they were all employees of the Dutch West India Company. But the interesting features of that document, to me now, are far more important than how to run that government and how to proceed as employees of the Dutch West India Company. The provisions that strike me particularly, and I hope you, was that they told Verhulst, one, don't try to conquer the Indians. We're not conquerors. We're here to trade with them. Two, treat them fairly and treat them as business people when you do your dealings with them. Three, you must accord people freedom of conscience. Now, that's not the same as freedom of religion that we have in the First Amendment, and it would be an exaggeration to say that the Dutch, even though they were 50 years ahead of everyone else, allowed the open practice of religion on New Netherlands soil. They did not. But in other locations, people were being killed just because of what they believed. And the Dutch did not want that. They wanted freedom of conscience or freedom of belief. And they went so far as to say, look, if you want to worship differently, we're all Dutch Reformed, and that's the official religion. But if you want to worship differently, if you're a Lutheran, and you do so privately, we're going to look the other way. And today that strikes us as almost bizarre, because now religions are practiced openly and under constitutional guarantee. But at the time it was quite revolutionary, and the Dutch were years ahead. And as a result of it, there were religions that could function quietly, Lutherans, Quakers. When Stuyvesant became governor later, he made that rather more difficult and got into some scrapes with Lutherans and with Quakers and Jews. But the official position of the Dutch government was to rebuke him from time to time when he tried to curtail some of these freedoms. So here's so that when we get to 1777, we're going to now look at a very interesting provision in the first Constitution, which says, no need to read it all, but just the big print, which says, the free exercise and enjoyment of religious profession and worship without discrimination or preference. Now this is now 100 years later, after the Dutch, shall forever hereafter be allowed within this state to all mankind. My goodness, can you imagine more majestic words? They built on the language that the Dutch imposed on Verhulst in the 1620s. So now we're 150 years later, 1777, and look at this remarkable language that John Jay and Robert Livingston and Gouverneur Morris wrote into our first Constitution. They speak about religious conscience now and forever. That was not true of every state. Now we'll go to, they were so keen on the idea that today we separate church and state because we do not want the church, religions mixing into government, and we don't want government mixing into houses of worship. So we have a separation of church and state, and we have thrived on that as a nation. I think that's one of the ways in which we have prevented religious strife and violence. So they were so keen on the idea that there be a separation of church and state that they wrote this provision. We have picture 8? Yeah. Okay. And whereas the ministers of the gospel are by their profession dedicated to the service of God and to the care of souls, and ought not to be diverted from the great duties of their function, therefore no minister of the gospel or priest of any denomination whatsoever shall at any time hereafter, under any presence or description whatever, be eligible or capable of holding any civil or military office or place within this state. That was an actual bar, an exclusion of the clergy from in the government. That exclusion does not exist today. Today, if a priest wants to run for office, we wouldn't say you're barred. But they were so keen on separating church and state that they wrote that provision in. And it may have been in part, I think, because the primary author of the New York State Constitution was John Jay, who was descended from, on one side Dutch and the other side Huguenot, had experienced, or his family had experienced, persecution in France under a different religious regime. And he carried that concern with him, and was no doubt, if he was a primary author of this Constitution of 1777, I have no doubt that it was his pen that wrote this provision here. May I ask whether any of you folks are naturalized citizens as opposed to having been born here? Any people that went through a naturalization ceremony? Anybody? So none of you. No, we were all sort of native-born Americans. Well, when I was a county judge in Dutchess County, the judges would all enjoy giving the oath of office to newly minted Americans. Naturalization ceremony, we called it. And they go through sign their oath as Americans, and it was a great celebration. We'd have music. They were jubilant. We were all happy, and it was one of the great joys of being a judge, because judges live somewhat in a world of strife and contentiousness and conflict, but the idea of minting new citizens was really a lot of fun. And I came across a phrase when I said, "Now repeat after me," and I would read this phrase, and it said something like, "I pledge allegiance to America, and I renounce and forbear any allegiance to any other," here's the phrase, "any other foreign prince or potentate." I thought and I would repeat it because that's the official oath that you read and that they read when they hold their hands up. And I said, what is this foreign prince or potentate business? And going back, checking it out, I don't know whether you know this, Paul, you're aware of it. A historian, Mary Bonamy is the one who explained all of this, that John Jay was concerned a long time ago about the same thing that Americans, I think needlessly, were concerned about with Al Smith and later with JFK, that one should not have a primary allegiance to Rome. And he was concerned that we be Americans or New Yorkers with our primary obligation to New York and not to Rome. And that was what was on his mind. That's why that phrase, "any foreign prince or potentate," Mary Bonamy says that the first draft of that was to the Pope, and then it got changed. So this is what was going on in 1777, and how they felt so strongly about a freedom of religion that today manifests itself in what we in New Yorkers like to think of as diversity. I mean, how many places are there under the sun in which so many religious groups get along more or less agreeably? There are strifes and there are a little bit of contentiousness here and there, but basically we live in religious peace. in contrast to the wars and the slaughters that went on for centuries before us on religious grounds. So that was a very important piece of the Constitution. We later learned through JFK that we have nothing to fear through John Kennedy's Catholicism. We embrace him and we embrace his belief, but at that time it was uppermost in their mind. The same, of course, for Al Smith, although there's no one in this room who's old enough to remember even the name of Al Smith, right? I'd like to hear from some of you, if you heard your parents talk about Al Smith. That'd be interesting. Maybe a little later on we'll hear some of you talk a little bit about that if you care to. All right, so who are these people who wrote the Constitution of 1777? John Jay, at the time, he was 31 years of age, and quite a dapper-looking fellow, descended, he was an aristocrat, he was a man of high order and well-educated, of the upper class, but obviously had a sensitivity for the public at large and for his duties. Next, that is, as you can see, that's Chancellor Robert Livingston, also aristocratic, and it should not surprise us that the people who wrote the Constitution were of a higher social order because they were educated, they held the jobs and the titles of importance. And there's a lot of pictures of Livingston online. If you go to Google and punch in Livingston, there's a dozen of them or 100. But I like this one because he's on a postage stamp, and I thought that was really cool, on a 1-cent stamp. And he was born in 1746, so that he was maybe also quite young. And the youngest one of all was Gouverneur Morris. What a handsome young dude he was. He was 25 at the time. So fresh out of Columbia College. I guess he was a scholar, and they must have thought well enough of him to appoint him to be one of the 3 people to write a constitution. Imagine a 25-year-old writing a constitution with no model and no track record of any kind. So there he is. We feel pretty good about them all. Morrisania in the Bronx, that's after Gouverneur Morris. And of course the Livingstons, as you know, are still around. They're around in Kingston, they're around in Poughkeepsie. And we even, my wife Julie, who was active in the Samuel Morse homestead, worked with Fran Reese and Willis Reese, and they come down the line from the Livingstons, right? So the Livingstons are around. They're still, in many cases, philanthropic and civic-minded, and it's really, really good to see that. And so what did they do in this Constitution? They created what we call a bicameral legislature. They said that the power of the legislature is going to reside in an assembly, and in the Senate they gave us 2 houses, much like the House of Commons and the House of Lords, and they set the foundation for what we have today, the Senate and the Assembly, and these guys did it back in 1777. So the Assembly was designed by size and representation. So as you can see, the bigger counties had bigger representation. Albany had 10, Dutchess 7, Westchester 6, Ulster 6, Suffolk 5, Queens 4, and so forth. And this was the form of representation. By that time, at that time, we also had Gloucester County, which was later given to Vermont. Now that was a huge mistake. Because we also gave away Dukes County in 1691. We gave away Nantucket and Martha's Vineyard. I mean, think of that. Well, what were we thinking? So when we go out there, when you folks go out to Martha's Vineyard or Nantucket, you know, you could walk a little bit prouder and say, hey, you know, make way for me. Okay. And what else do we find in this Constitution of interest? Let's look at Article 37. Treatment of Indians. Look at that language and how extraordinary it is. Look at the history we've had with Indians. As many of you know, we've had a bumpy history with American Indians. But if you can read that, this is a provision that's really full of heart. So take a moment to look at it. Well, they talk of peace, they talk of amity, which brings us back to the business about Manhattan Island and $24 that we bought Manhattan Island for $24. The scholars will tell us, unlike what we learned in junior high school, that this was not an instance in which our Dutch forebears went over to the Indians and said, here's 24 bucks, now give us Manhattan. That was not quite what was going on. The scholars tell us that the Indians did not have a conception of land ownership that we did. It was inconceivable to them that anyone could actually own land, just as it would be inconceivable to us that we would own, a piece of the sky, if you think of it that way. And the scholars will tell us that this was a treaty in which we were allowed ingress and egress on that land. It was exchanged. There was an exchange of gifts. Maybe the gifts came to $24. They shook hands. They probably smoked a peace pipe. And it was really an understanding with one another that we're allowed to enter on that land. We look after them. They look after us. The $27 business, or 24, whatever it is, sort of grew up into what was a fairy tale. That transaction also was recorded in a letter. It's called the Schrachen letter. That letter exists. When I think the original may have been brought over 3 or 4 years ago, when at the Dutch, at one of the Dutch anniversaries, and we have copies of it. And you can read the Schrachen letter in which the writer goes back to the Netherlands and talks about the acquisition of Manhattan. And I think the scholars would say what he meant by acquisition of Manhattan, he probably meant something like tenancy rights, or the rights where we could be there. So let's look at where we've been since that time. The Constitution of 1777 did not contain the same Bill of Rights that we had promulgated 10 years later. We were still in a state of flux, and there were certain rights enacted, engrafted into the 1777 Constitution, among them freedom of religion, which you've seen, and the right to vote, and how to run a government. After the United States Constitution was enacted in 1787, we then in New York, in our Constitution of 1821, we amended the Constitution of 1777, and we engrafted on what we recognize today as the Bill of Rights. First Amendment, freedom of speech. Fourth Amendment, freedom of search and seizure. Fifth Amendment, due process, double jeopardy. Sixth Amendment, right to speedy trial. Eighth Amendment, cruel and unusual punishment, and so forth. But we in New York, in 1787, we were the first entity to use the phrase due process of law. The notion of due process goes back to Magna Carta, 800 years. And in 1215, the royalty, the barons, sat down with the King of England, King John, and they extracted from him an understanding that he should not see himself as being above the law. That has resonated with us off and on for 800 years, because the language in that says that no English person can be arrested, seized, stripped of life, liberty, without the law of the land. And that phrase, the law of the land, was over the centuries morphed into the phrase due process of law. So that in the United States today, when we speak of our constitutional rights, primary among them is that the government shall not deprive any person of life, liberty, or property without due process of law, which means essentially fairness, that it should not and cannot be done arbitrarily. That phrase found its first expression in a New York statute in 1787. So we can feel pretty good about our legacy. That phrase, due process of law, was enacted in a New York statute a year before it found itself in the United States Constitution in 1788 in the Fifth Amendment and later in the 14th Amendment. So look at what we have to be thankful about. We can come out here on a nice Friday evening, sit around, look at all this and say, well, we began as Dutch, we then became English, we then became Americans. We not only are Americans, but we're Americans who value our legacy, who can sit down like this and smile and say, yeah, it looks pretty good. Let's just hope that we continue as we are, as recognizing the rule of law, recognizing diversity, recognizing peaceability, and recognizing our majestic form of government. Thank you very much.
Judge, thank you so much. And I will tell you, you will not get for the opportunity for the rest of your life to have a Court of Appeals judge come here and talk to you about these things. You're going to have a case. You're going to have to lose it in the Supreme Court. You're going to have to go to the appellate division, lose it again. You're going to have to bring it to the Court of Appeals. So, Judge, thank you so much. And I have to say that Judge Rosenblatt was such an absolute pleasure, one of the nicest people I think I've ever met. And I have to say I was a little intimidated. I haven't, usually if I run into a Court of Appeals judge, he's going to be yelling at me for something. So, Judge, thank you so much. And do we have any questions for the judge?
Hey, I would like you to come up here and help answer them.
Oh, all right. Yeah, howdy. I agree with these three guys were really brilliant. I'm a little confused. It was a convention, and the conventioners chose those three?
Yes, the convention
Right.
appointed them.
So they wrote it in a room with the other conventioners?
Well, the convention itself is responsible for it, but they appointed a committee. Obviously, if you got a large convention, you only need three or four
So the three-man
people
committee
that
went
hold it.
off
Yeah.
and wrote it
Yeah.
separately?
Yeah, we don't
And
know
Where
exactly
did they get
who
their
wrote what.
verbiage from?
Huh?
Where did they get their verbiage? They were making it up. Was it
They made up a lot.
Greek-based,
There were several other constitutions before it. We were about the seventh or so. So there had been New Hampshire wrote the first constitution. I think they wrote it before the Declaration of Independence. And there were several others. I've got the list here. And if you go online, just punch in Google early state constitutions, you'll see some language. But I don't want to sound too cocky about it. But the New York Constitution was special. We probably got a lot of language because the thinking in the colonies was similar. These men were talking to one another. They were all men. The women came later, of course. And they had notions that were Lockean, and they also had a history of English common law. But when Professor John Kaminsky was here about 3 years ago, he knows more about this period probably than anyone else on this planet. So I spoke to him not long ago and asked him, John, is it fair to say, because I think I read it somewhere in one of your writings, that the United States Constitution borrowed a lot of its structure and balance from New York's Constitution? John said, that's right. They borrowed the language from New York because when Pennsylvania drew its Constitution, they gave almost no power to the executive because they were so leery of executive power. We just got out from under George III. So they gave the governor very little power and too much to the people, and it got a little bit disordered. But John Kaminsky says that the New York Constitution and the balance between the legislature and the governor was, as John Kaminsky says, like Goldilocks. It was just right.
And it is interesting that I believe that New York was the second to the last Constitution, but by and large, these people were writing this for the first time. And the judge can tell you that in courts of law, we deal with precedent. Sometimes things have to be repeated the same way, and you sometimes say, somebody once wrote that for the first time. But the fact that they did this at the age they did, with the foresight they did, and one of the things that was really amazing is there was the convention. These three people were the main people who were involved, but particularly Robert Livingston and Gouverneur Morris, they pushed through the convention. I don't know if you've been around and tried to come to a consensus with a large number of people. It's not easy. And as important as what they brought up and what they argued was what they prevented through procedure from coming up to being argued. And this is one of the New York Constitution was one of the only ones. You look at all those early state constitutions, they all had to be amended again and again and again and again right from the very start. New York, I think the New York Constitution went 50 years without any substantive revisions, which says so much. And I think that when you talk to people, they say the United States Constitution is based primarily on the New York State Constitution and the Massachusetts Constitution, which was written primarily by John Adams. And I think that they're just giving John Adams a little bit of, it was New York. So it really was an amazing event.
But we like John Adams. Remember that television series played by Paul? What's his name? Giamatti. Wasn't that wonderful? Wasn't he a great Adams? So you'd see John Adams not as an aristocrat, but like as a farmer, and he goes into a pile of manure and he picks it up and he says, "Son, this is what it's all about." Isn't that great?
It really was the workhorse of the founding fathers, and it's nice to see him getting some credit finally.
Yeah, we like John Adams.
I'm curious about the opposition in New York to the ratification of the Constitution in 1788. In particular, Governor Clinton was one of the leading opponents to ratifying that Constitution, and led to a bitter dispute with Hamilton, for sure, thus with Jay. What was some of the reasons why Clinton was so opposed to the ratification of the U.S. Constitution?
Boy, what a great question that is, and what great observation, and what an offshoot that is. It's so apt to this discussion here, because this discussion here centers around 1777. Then we became a nation, so-called, in 1788. And when New York convened to ask itself, do we want to join the Union, the sentiment in New York at that time was radically no. We did not want to join the Union. We were about the most powerful state, New York and Virginia. We thought our power would be diluted. We thought we would lose our financial power by virtue of the port of New York, where we collected taxes. We thought we would lose that in interstate commerce. But one reason that shines out is that the Constitution, as drafted in Philadelphia, contained no Bill of Rights. And on the minds of all of us in New York is, I'm going to guess that if we folks here were the delegates to the convention, we would think very much like our forebears, and we would say, wait a minute, you want us to join a union? We don't know what this union is going to be like. We don't know what this federal government is going to bring. It sounds a little bit like Ronald Reagan, and saying, what is this federal government going to come to? And they more or less predicted that the federal government is going to be large and uncontrollable. And they were concerned about the power of the federal government keeping its thumb on the states and repressing individual liberty. So the conventioners contacted James Madison and others and said that we will buy into this and we will join the Union if we know there's a Bill of Rights in it. Madison said, not now. You've got to buy into it now. We're not going to take any conditional joining. You're either in or out. And at that point, the vote was still against joining. But after Virginia and New Hampshire joined the Union, there was a provision that when 9 states joined out of the 13, we had a nation. So 9 states joined, and there we were. And the question before the delegation was, do we join the Union, kicking and screaming, so to speak, or do we join Canada, or do we become a nation of our own? And the various drafts of the convention revealed that we, in an act of trust, we said, okay, we will join the Union on condition that there be a Bill of Rights. Madison said no. Then Melancton Smith changed the language and said, in full confidence that. And Madison was good to his word. In 1791, the Bill of Rights was enacted and contained many of the liberties that we had conceived of in New York. It's an extraordinary story. And Clinton was perhaps the most resistant to joining the Union, and his spokesman, Melancton Smith, was an ardent and articulate anti-federalist who went head-to-head with Hamilton and who carried the day often against Hamilton, but we were backed into a corner in New York because we were either cut loose to join Canada or become a nation of our own. And fortunately, we did buy into it, and 3 years later, we were fine. But thanks for raising that point. And don't forget Melancton Smith. He's one of our heroes.
There's a question over here.
After the New York State Constitution was drafted, did it have to go through a ratification process similar to that of the federal Constitution?
Yeah, yes, the Constitutional Conventions occurred in 1821. It goes to the voters. The voters voted up or down. Like in our own lifetime, whenever there's an amendment, you can remember over the years there might be an amendment to do this or do that. You know, when you go into the voting booth and they have something on the wall which is lengthy and complex and verbose, and you ask yourself, how much money is this going to cost us? Any amendment has to go by the voters. The Constitution was altered substantially in 1821. Then in 1869 was the next Constitutional Convention. The entire court system was changed. Then in the 1869, then the 1920s under Al Smith, I think the Constitutional Convention of 1938 was a change in the Constitution in which new rights evolved, notably taking care of the poor. There's no provision in the United States Constitution that allows anybody to get a penny from the federal government. Those are all statutes. The Constitution of the United States is a negative document. It only says the Congress shall not do this and shall not do that. But the right to an education is a New York State Constitution provision, and the right and the obligation to take care of the poor is in the New York State Constitution. There's nothing like that in the United States Constitution. So short answer is yes, all constitutional amendments and provisions have to be ratified by the voters.
Judge, I think the question had to do whether that original document was ratified by voters.
I would.
Good
The
question. The question was, so that everybody
yeah.
upstairs hears, was the question is whether the Constitution of 1777 had to follow a formal ratification process, or whether simply approval by the Constitutional Convention was acceptable to form the New York State government.
Does anybody know the answer to that question? I think they were sort of flying on the seat of their pants somewhat. I'm going to guess maybe not. I think I remember reading somewhere that it did not go through that process of voter approval, but that
it didn't.
Right,
it was passed on April 20th by the convention. By doing that, it became, in fact, the Constitution of New York State. It was read 2 days later on the front steps facing Wall Street, and there was an issue because the Constitutional Convention really was the provincial Congress. They eventually molded into, by coming here and doing this, the Constitutional Convention. But the provincial Congress hadn't been elected in some time. When they were in New York City, that was an elected group. After that, they kind of just stayed beyond what ordinarily would have been their term. So there was some discussion of, is this group actually an elected group representing the citizens of New York State? And two, do they have the power to do this? But you know what? They did it. We're glad they did it, and we're glad they did it here.
Good point. Thanks for raising that. You feel free to ask the questions, and the harder they are, the more I'm going to look to Paul.
I just make them up anyway, so.
Judge, I was always under the understanding that the fellows like John Jay and that used the Magna Carta as a model for designing this. Could you explain a little bit about what the Magna Carta is all about?
Yeah, the language of Magna Carta, Article 39, is the language that resonates to us. The rest of Magna Carta would have little or no bearing on our lives in the New World. It was technical, complex, and had a lot of provisions dealing with the relationships among the nobles. And if you look at it, your eyes would glaze over. When we speak of Magna Carta as our legacy, we think of Article 39, the majestic language that no person shall be, I mean, I guess we can probably find it here if anybody's got a quick computer, but it says something to the effect that the barons, who were the only people who could stand up to the king, extracted from him because they felt oppressed and they felt that he was acting too tyrannical, a provision that no Englishman can be, that property be taken away or put in jail or harmed in any way without absent the law of the land, which is another way of saying that the king would no longer consider himself the agent of God, all-powerful, able to do anything, because at that time, in 1215, when Magna Carta was written, most of the world believed that the kings were agents of God, that they were put here divinely, and when the king spoke, it was God speaking. Well, they still carried that idea a little bit after that, but the barons said, well, that's all well and good about God, but while we're here on earth, we want an understanding with you that you are not above the law and that you cannot act arbitrarily and just say, well, I want that person killed, I don't like his looks. And so the language of Article 39 was, no person shall be ... harmed absent the law of the land. That phrase, the law of the land, over the centuries, found expression in 1787 in New York and ultimately in the United States Constitution, that no person shall be harmed. We use the phrase, no person shall be deprived of life, liberty, or property without due process of law. And that phrase, the liberty interest, no person shall be deprived of life, liberty, or property without due process of law. Okay, that means you can't go to jail without a fair trial. No person shall be deprived of life. That means that the government can't just kill people willy-nilly. There's got to be a process and a death penalty that's constitutional. No person shall be denied property without due process of law, meaning the government can't take your land away. And that's why we have eminent domain and payment and so forth. The phrase, no person shall be denied life, liberty, or property without due process of law, had a very, very ugly start in the United States. It was written into the United States Constitution in 1787, and it appears in the Fifth Amendment saying no person shall be denied life, liberty, or property. Focus on that phrase for a moment. So the slave owner in the Dred Scott case went up to the United States Supreme Court and says, wait a minute, it's written down here in the Fifth Amendment, no person, me, shall be denied life, liberty, or property without due process of law. This slave thinks himself free by virtue of the Missouri Compromise, and we think that's unconstitutional because the Missouri Compromise had it that a person is free when going to a free state. How can the government do that? We're relying on the Fifth Amendment. The government, he says, should honor the Fifth Amendment, which says no person shall be denied life, liberty, or property. And by giving his slave liberty, he's being denied property. So what a perverse use that is of the Fifth Amendment. That was the first time the Fifth Amendment was construed by the United States Supreme Court, and it is one of the ugliest constructions we've ever encountered. Extraordinary. Now we prize not so much the property element of it, we prize the liberty interest of it, because nobody at that time thought that Dred Scott had a liberty interest. What about the phrase, no person shall be denied life or liberty? Well, they just ignored that part in the Dred Scott case, which, by the way, was not unanimous. It was Justice Roger Taney wrote it for a majority. It was, I think, maybe 6-3 or 7-2 in the United States Supreme Court. And we in New York encountered a similar, in my court, rather well before my time, I should say, a similar instance in which a slave proclaimed himself entitled to freedom because he was set foot in New York. And the owner said, well, under Dred Scott, that slave cannot be free, even though he's in a free state, because the ownership's still attached. In my court, in a case called People ex rel Lemon, simply ignored the Dred Scott case. How they got away with it is still quite extraordinary. It was during a time of conflict, and then that was the majority opinion. One of the concurring judges who did not write the majority opinion did give us a clue as to what was going on. Judge William Wright, Sullivan County, said, well, we do know about Dred Scott, and we know that we're obligated to follow cases of the United States Supreme Court, but the Dred Scott case turned not on the liberty or property element, but it turned on the fact that in the first paragraph, the United States, or rather early in the decision, the United States Supreme Court said, Dred Scott loses right off the bat because he's not a person and he's not a citizen, therefore he cannot bring suit. The rest of the 200 pages was all what we call dictum, and we don't have to follow that. That was William Wright. Pretty good.
That's a smart judge.
Smart judge.
It's more of a comment. The United States Constitution indeed had categories of people who were not persons, and I imagine that a number of states had them as well. That treatment of Indians portion, I was never aware of that, and that is absolutely astounding. And the case that you just spoke about is like this is the underpinning for that state of mind. You know, we don't think that human creatures are not persons just by law. It's not, I mean, I just think that's incredible that New York was on the forefront on that.
Yeah, I didn't realize that until in preparation for our talk tonight, I looked at the Constitution of 1777 for features of interest, and I found that. I thought, boy, that really makes you feel good. You're quite right about the phrase person, that in the United States Constitution, slaves were considered 3/5 of a person, right? 3/5 vote. So when they tallied up the number of people in the slave states, the slaves counted for representation in the Congress, the slaves counted as 3/5 of a person. So that makes your point. I mean, it's just astonishing to think that the slave was considered not a full person, but 3/5 of a person, and that Judge Tawney, in the Dred Scott decision, didn't even consider him 3/5 of a person. He's a non-person, a non-entity. It's a chattel, like a horse or a cow or a wagon.
Judge, thank you so much.
Great.
Thank you so much. NYU Law School is one of the top law schools in the United States. Do you know how much you would pay to hear this? Provided you got in. I actually I applied to Harvard Law School, and I'm still waiting to hear back from them. And if I hear, I'm going back. Again, Judge, thank you so much. That was absolutely wonderful. We thank you for coming here. We thank you for sharing. We thank you for all that you do. So, and again, it's people like Judge Rosenblatt who have really made this such a special series. And we have so many other people. Again, Joe Tantil and I stopped adding names on because it got to be too much. But this is a group effort. And we really appreciate all the people who make this possible. So we do want to take the opportunity to thank all of them, and particularly all of our presenters, and tonight, Judge Rosenblatt. As I said last time, due to the holiday schedule, we are not going to be having a presentation in December. And in January, we are going to have what will be the last presentation in this series, Lost Roundout, the story of urban removal. And that is a wonderful film about the destruction of Roundout, of a lot of the buildings down on the Strand. But it's also about a rebirth. Lynn Woods and Stephen Blauweiss have done a wonderful job, so they're going to actually show the film. And again, like all good things, this series too must come to an end, so this will be the last presentation. We certainly hope everyone can be there, and we will see you in January. Have a wonderful holiday.